So, welcome very much to this side event today, realizing reparative justice. That's a matter for the entire Rome Statute system. And I thank in particular Finland and Sweden, as well as Germany, for supporting this side event. Germany supporting it with the lunch package that you hopefully all got downstairs at the cafeteria. And if not, you're free to please help yourselves. We have a fantastic panel to speak to this important subject of reparative justice, which is at the very heart of the Rome Statute system. And Ibrahim Yilla, the vice chair of the board of directors, representing the African group of states, will welcome this panel. He is our reparation focal point, together also with Andres Palmas, and that is why these two board members are today with us for this panel. So, Ibrahim, the floor is yours. Thank you.
Thank you very much, Francisca. Let me say a few welcome remarks to distinguished members of this panel. On behalf of the Board of Directors of the Trust Fund for Victims, I have the privilege of welcoming you to today's side event, Realizing Reparative Justice. We speak today about the indispensable link between justice and reparations within the Rome Statute system, and therefore between the court and the Trust Fund for Victims. It is my honor to welcome this distinguished panel today, which represents different parties involved in making the Rome Statute system of reparative justice a reality. First, let me take this opportunity to welcome the President of the Court, President Hofmanski, who has been a judge in the Appeals Chamber since 2015. The judicial process is clearly at the heart of the Rome Statute reparative justice system and form an in of themselves a satisfaction for the victims of crimes. Beyond a conviction, it is important to note that the judicial system also gets on record what has happened and again forms part of the satisfaction of victims. The Rome Statute has gone beyond that, however, and combined for the first time individual accountability of perpetrators with the accountability for reparations to the victims of their crimes. All these aspects belong to the judicial aspects that are governed by the chambers of the court. Thank you, Mr. President, for participating in today's side event and addressing the indispensable role of the chambers in this process. But the promise of the Rome Statute is also that of reparations with the means of the convicted person, even though there may be a very high number of victims. For that purpose, the Rome Statute provided for a mechanism, the Trust Fund for Victims, that would put in place such reparations not only on an individual level, but for all the victims of these crimes. In this respect, the Trust Fund for Victims' work is essential to realizing reparations. The two reparation focal points of the Board of Directors, my humble self and my colleague Andres Palmas, are part of this panel today. The Rome Statute system does not stop at a means of the convicted person, but gives the Board of Directors the opportunity to use other resources to complement the payment of reparation awards of the court against the convicted person. These other resources may come from states, and from private actors. To date, state parties have been the main contributors to the Trust Fund for Victims, and the convicted persons have not yet contributed a single penny to the reparations awards directed against them. Today, we hear from an important donor of the Trust Fund, Ambassador Savela, representing Finland. Welcome, Ambassador. But the Rome Statute's reparative justice system does not only need the support of state parties, but also non-state parties, be it financially, politically, or morally. The positive reparative effect that the Trust Fund for Victim programs have in situation countries, the transformation in the lives of victims that we aim to achieve is of interest to all states and address also their calls for long-lasting peace and stability and for the many different aspects of the international development agenda. We're honored to have today with us Ambassador Beth Van Schaak. Welcome, Ambassador. An important actor in the Rome Statute reparative justice system are the legal representative of victims. The criminal conviction and sentence and participation of victims in the proceedings are also an expression of the victim's right to access to justice. Beyond this, victims are parties to the reparation proceedings that take place after conviction decision. In addition, legal representatives play a role during the implementation of reparations. We're also welcoming today the Principal Counsel of the Office of the Public Counsel for Victims, Paulina Masida. Finally, I welcome the independent researchers of Edinburgh University, procured by the Trust Fund for Victims, who present their preliminary outcome of their evaluation of the Katanga case, looking foremost into whether there has indeed been a reparative effect. It is the first evaluation of court-ordered reparations to date. I know you are curious. Are you curious? Stay focused till the end of this session. Clearly, there are many other actors, but this is only the first session of this kind. We hope to have many more events that speak about, discuss, and analyze how courts, parties, states, and the Trust Fund for Victims together make reparative justice a reality. The court has issued to date 3 final reparation orders in the cases of Katanga, Lubanga, and Almadi. Reparation implementation in these 3 cases is ongoing. The case of Katanga is in the final stage. The reparation order in the case Ntaganda is not yet final, and the judicial reparation proceedings are ongoing. Nevertheless, the Trust Fund for Victims is conducting an initial reparation program for those priority victims who are in urgent need. At this stage, may I firstly welcome these distinguished members of the panel to this discussion, and I call on Francisca to do the opening courtesies to welcome the President and other members of the side table. Thank you very much for your attention. I look forward to seeing you till the end of this session.
Thank you so much, Vice Chair, to give these welcoming remarks to this distinguished and honorable panel. And without much ado, I would like to give the floor to the President of the Court. We have heard from him this morning already about the visit to the Central African Republic that we had together just indeed 2 weeks ago, returning a week ago. And I'm very honored that you are here today and present the core of what the court is about, the judicial part of this reparative justice. Thank you very much.
Thank you very much, Madam Chair. Excellencies, ladies and gentlemen, I would like to thank Finland's Sweden and the Trust Fund for Victims for organizing this timely event and for inviting me to provide some reflections on the role of the ICC in achieving reparative justice. I would like also ask for apology, but I'm not able to stay to the end of the meeting because of the bilateral meetings we had in the meeting. I'm very sorry, in particular because of the Q&A session, which is in the end of the meeting. But I hope you will understand. The topic is highly important. One that is really also close to my heart. The ICC role in achieving reparative justice can be described on three levels, threefolded. The first, in a broader sense, the court enables victims' interaction with the court. When this interaction is meaningful, it may in some way repair. Second, and most evident, the court orders reparations to address harm suffered by the victims of the crimes related to a conviction. The Trust Fund for Victims may either implement reparations order or assist victims directly through its assistant mandate. Third, the ICC is part of a broader, more comprehensive international system of reparative justice. States, and not the ICC, have the primary responsibility to repair harm, and the ICC complements national jurisdictions in their obligations to do so. The ICC's system of reparative justice enshrined in Article 75 of the Rome Statute, which sets out the foundations for the reparations proceedings. However, reparative justice goes beyond that. A victim-sensitive approach guides the Rome Statute, which allows victims to interact with the courts at different stages of the proceedings. This is at the core of the ICC system of reparative justice. As I said earlier, when victims or affected communities interact with the court, it may already lead to some kind of repair. Contrarily, if victims are excluded from the justice process, this may lead to further victimization and harm. This is at the heart of the ICC's reparation principle to do no harm. For example, the statute provides victims with the possibility to make representations before the pretrial chamber at the very early stage when the prosecutor requests authorization to start investigation in a given situation. Likewise, when an individual is identified as a suspect, victims have the possibility to participate and express their views at pretrial and trial proceedings. This has been done in practice through a common legal representative. As stated above, victims' interaction with the court and representation in particular must be guided by the do not harm principle. This means that any negative impact must be lower than the positive outcome. The principle comes hand in hand with the principle of non-discrimination and the transformative capacity of reparations, in which pre-existing situations of discrimination are addressed when victims interact with the ICC. Bearing this in mind, reparations proceedings so far have been gender inclusive and child sensitive. Priority has also been given to vulnerable victims, such victims of sexual and gender-based violence and children. Consultation process also key to achieving reparative justice. Considering the multiple situations in which the court is involved and the inevitably cultural, technological, and language barriers that exist between the court and the victims, outreach is key. Victims will not participate or apply for reparations unless they are not provided with information in a manner they understand. As regards the court's role to order reparations, to date, all representations orders have been implemented or are being implemented through the Trust Fund for Victims in light of the indigence of the convicted persons, as already mentioned. For example, in the Lubanga case, so far the trial chamber has found more than 2,000 victims as eligible to benefit from reparations, of which over 500 are currently benefiting from the service-based collective reparations. In the Katanga case, reparations ordered by the trial chamber are almost all fully implemented to date, having benefited approximately 300 victims. The expected completion is estimated to at least March 2023. In the Almaty case, implementation of the court-ordered reparation are ongoing with nearly 950 victims having benefited from individual reparations. The ceremony of the distribution of the symbolic reparation award to UNESCO and Mali took place in March 2021. The implementation of collective reparation is ongoing. Reparation proceedings are ongoing in the Ongwen and Naganda cases. The ICC reparative justice system is limited to the crimes within the court's jurisdiction, but most importantly, to the charges for which there is a conviction. Here, the importance of the Trust Fund for Victims Assistance mandate come into play, which can assist victims in all countries. Most importantly, the assistance mandates also the Trust Fund to assist victims early on, for example, when investigations are ongoing or in the event of an acquittal. For example, in the Central African Republic, where there was an acquittal in one case and pre-trial and trials are ongoing in other cases, the Trust Fund started an assistance mandate program in 2020, which to date has assisted thousands of victims, among other, of sexual and gender violence. Just 10 days ago, I was visiting Bangui, where I had the chance to meet some of the beneficiaries of the projects as well as the implementing partners. I was deeply impressed by the professionalism of the partner organizations, and was rewarding to hear from the victims' survivors how the Trust Fund for Victims projects has made a concrete positive effect on their lives through health services, psychological rehabilitation, and income generation activities. Excellencies, ladies and gentlemen, lastly, but perhaps most importantly, states bear the principal responsibility to repair victims of crimes within the jurisdiction of the court, but also beyond that, all victims of gross violation of human rights. Article 75(6) of the statute provides that nothing in this article shall be interpreted as prejudicing the rights of victims under national and international law. The UN basic principles establish these rights, and hence the state's obligations to guarantee access to justice and repair victims for harm suffered. Moreover, state parties have the responsibility to cooperate with the court. To date, all convicted persons have been found indigent. This means The Trust Fund for Victims had advanced funds to implement the reparation orders by trial chambers on behalf of the convicted persons. The Rome Statute provides in Article 57(3) a possibility for the pre-trial chamber to request state parties to cooperate in the identification and eventual freezing of funds, assets or properties for eventual reparations. This obligation to cooperate with the court does not create upon conviction. To the contrary, state parties have the obligation to assist the court in monitoring the financial situation of the convicted person. Lastly, although not responsibility but voluntary contribution, states may donate funds to the Trust Fund for Victims. This is indeed critically important to make the implementation of reparation orders possible, and I would like to thank voluntarily all donors, states that have made the Trust Fund's activities possible so far. Excellencies, ladies and gentlemen, it is evident that the concept of reparative justice goes beyond court-ordered reparations. It involves a victim-sensitive system of international criminal justice, a system that involves the court, but principally states. The ICC's role is significant but limited to its jurisdiction, which complements domestic jurisdictions. States have the leading role to bring justice for victims, either to the national judiciary or other restorative justice mechanisms, or through cooperation with the ICC in respect of victims of crimes under the court's jurisdiction. At the same time, we should not underestimate the importance of the ICC's role as a permanent anchor of the international criminal justice system, or the significance of the Rome Statute's victim-oriented provisions in providing inspiration to domestic systems. Thank you very much for your attention.
Thank you very much, President Hofmanski. I think you are coining really specific words here. A victim-sensitized system of international criminal justice. I think that is a phrase that we can keep in mind, and also the ICC as a permanent anchor. So, and with your call for the role of the states, I give the floor to Ambassador Savile, who is the Deputy Director General of the Legal Service at the Finnish Ministry for Foreign Affairs, has been the ambassador to Israel and Cyprus, has seen trust fund programs in 2010, as you disclosed to us on Friday at our event on children born out of war, as part of the 16 days of activism. So thank you for joining us here today. Thank you for the support of Finland. And you have the floor, Ambassador.
Thank you very much, Franziska. Excellencies, ladies and gentlemen, as we all know, this year we celebrate the 20th anniversary of the entry into force of the Rome Statute. At the heart of the Rome Statute system was always the promise to focus on victims, to ensure we hear their voices through meaningful participation and provide assistance and reparation for the unfathomable suffering they have endured. The Rome Statute and the International Criminal Court did pioneering work in giving the victims opportunity to be active participants in the proceedings. Also, as we have heard, they can be awarded reparation, which was a novelty in international criminal justice. The ICC has come a long way since its establishment. Today, the ICC is involved in an ever-growing number of situations and a record number of active cases in court proceedings. The grim reality is that despite our efforts, to prevent atrocities. Most serious international crimes continue to take place around the world. The ICC continues to be a beacon of accountability and is needed today as much as ever. To date, the court has issued final reparation orders in 3 cases, as we have just heard, and the judicial proceedings are ongoing for reparations in 2 more. The full spectrum of the ICC activities, from preliminary investigation to the implementation of reparation orders, is now in use. Dear fellow participants, I welcome this opportunity to offer you some reflections from the perspective of a donor government, Finland, on the value of reparative justice and the work of the Trust Fund for Victims, focusing on 3 issues. First, reparations are a key component of international criminal justice today. Victims and their testimonies are central to ensure accountability for the most serious international crimes, but they also have a right to receive support, to lead dignified lives and overcome the suffering endured. Without reparations, international criminal justice would be limited to delivering judgments and incomplete to truly contribute to sustaining peace. Second, the ICC system relies on the Trust Fund for Victims to implement the reparation orders. The Trust Fund is an integral part of the Rome Statute system. It serves an important statutory function. To date, as we have already previously heard, all those accused at the ICC have been found indigent. This leads to the Trust Fund being fully reliant on donor support to finance its activities in implementing reparation orders. And while Trust Fund has been working tirelessly to widen its donor base, most funding today comes from state parties, such as my own. Finland is a long-standing supporter of the Trust Fund since its establishment. We have so far concluded already several multi-annual funding agreements to support the assistance mandate of the fund from our official development assistance, ODA. We continue to believe that the assistance programs of the Trust Fund provide an important way to support victims of atrocities, even when the investigations and trials are still ongoing. Assistance programs, while not directly linked to reparation awards, are still an integral part of reparative justice. As Franziska mentioned, I have witnessed this myself. It's really gratifying to see how much these assistance programs can support individual victims. But following the issuance of several significant reparations orders over the recent years, we are now complementing our support to the assistance mandate activities with dedicated support for the implementation of reparation orders. This financial support comes from our non-ODA funds. This year we will continue to support the reparations awarded by the ICC to the former child soldiers in the Lubanga case. The third and final point I wish to underline today is the need to continue and strengthen our support to the Rome Statute system, the ICC and the Trust Fund for Victims in particular. Implementation of reparation orders is a test case for the credibility of the promise we made more than 20 years ago to deliver for the victims. If reparation awards cannot be implemented, we will fail this promise. At the same time, victims of the most serious international crimes deserve our support in ways that go beyond the reparation awards. While the Trust Fund for Victims cannot be the only provider, the expertise it has built can and should be used in designing other national or international support programs for the victims. Finland, as a long-standing and committed supporter of the Trust Fund, will continue to do its part. We call on all others to do the same. Thank you.
Thank you so much, Ambassador, and thank you in particular for the contributions, also for the Lubanga case, which is where we have a huge need at the moment to continue at the end of next year into a third year. So we really need to raise funds for that. And yeah, thank you for so many really crucial points you made also about the role of the TFV as an integral part of the Rome Statute system and referring to the expertise that has been built in this team over many years. So thank you for underlining that as well. You referred also, both of you, the President and you, to the non-state parties. And we have the great honor to have here with us today the Ambassador at Large for Global Criminal Justice from the Office of Global Criminal Justice, Beth van Schraak. And it's a bit like a miracle that after there was an executive order at one point not too far into the past, that we have such a great supporter, an insider of international criminal law and international justice, and supporter at the Kampala conference to get the crime of aggression into the Rome Statute. To have you with us here today and speak about this so important aspect, reparative justice. I'm very grateful, and you have the floor. Thank you very much.
Well, thank you very much. It's a real honor to be here as the 6th Ambassador at Large for Global Criminal Justice. I want to thank the Trust Fund, obviously, for convening this conversation, and the delegations of Sweden and Finland for doing so, and also for inviting the United States participation. I also want to thank many of you here who I know are working tirelessly on behalf of victims the world over to advance justice and to make sure that victims and survivors are at the center of international justice efforts. We've heard so much about how victims inspire the daily work of investigators and prosecutors, and they're often the witnesses who provide really compelling testimony to enable prosecutors to prove the charges that they have levied against perpetrators. But at the same time, I think we should all recognize that victims and survivors are also experts to whom governments and others should consult, and as my government does, when they're designing new systems of restorative and retributive justice. Before joining the U.S. government, I had the honor and the privilege to represent a number of survivors in their efforts to achieve justice, generally in U.S. courts, but often also in courts around the world. And as such, this side event involves an issue that's very personal to me and that I have made central to my mandate as Ambassador at Large. As an advocate, I regularly would visit the homes of families who had experienced awful events, and I would hear firsthand what their loved ones had gone through. They still, nonetheless, had the strength to fight for justice, not only for themselves, their families, and their communities, but also to try and strengthen the system more broadly for others who may be complete strangers to them for the future. I also came to realize that often my clients felt alienated by the legal system that they were operating within. They felt re-traumatized by the process of bearing witness. In many criminal cases, in many criminal law systems, including in my own, survivors and victims are often mere witnesses for the prosecution. And they don't have necessarily participatory or other standing rights to be able to shape the proceedings going forward. And I think the Rome Statute system has done a good job of starting to change that and to put victims and survivors at the center of the system and not just on the periphery. It also has become clear, as I represented my clients around the world, that whatever conviction or sentence is achieved, at the end of the day, it doesn't necessarily mitigate the day-to-day realities of survivors or their families. My predecessor in this role, Ambassador Rapp, whom I think many of you probably know, he'll be here eventually at some point. He's still at large in the world advancing these issues. He was the chief prosecutor of the Special Court for Sierra Leone, and he would recount how witnesses would tell him that the verdict was incredibly welcome and had broad reverberations throughout their communities. But they couldn't eat it. They couldn't eat the verdict. It didn't change their day-to-day lives. And many of them returned to their home villages to a life of poverty and of want, and their life paths having been indelibly altered. No amount of work that we do as lawyers or diplomats can ever truly make whole individuals who have experienced international crimes, but we can do more to give them a platform to bear witness, to empower them, and to establish better systems to compensate them for the losses they have experienced, to support them, their families, and their communities as they attempt to rebuild their lives and move forward. And this is where victim funds and efforts to pursue restorative justice and reparative justice are so essential. So in the remainder of my remarks, I'll talk a little bit about the role of victim funds, drawing on my own system and our still nascent efforts to build these institutions into our system, and then touch upon the critical role of the Trust Fund for Victims in the Rome Statute system and in contributing to transitional justice efforts around the world in ICC situation countries. So in the US, we're continuing to look for ways to implement the promise of reparative justice. Congress has iterated upon various programs over the years aimed at helping families to recover physically, psychologically, and financially from the crimes that have been inflicted on them. A really early expression is in the 1984 Crime Victims Act, which encouraged our US states, which bear the main burden of adjudicating criminal law, to maintain programs to provide services to victims of crime. It established a crime victims fund that can pay out compensation, that is funded through criminal fines, special assessments that are paid for by criminal convicted offenders, but also gifts, donations, and bequests from others. Since then, we have progressively expanded upon our thinking on how trust funds can support victims, including within historically marginalized communities. So in 1994, the United States enacted the Violence Against Women Act. It was authored by then Senator Joseph Biden. The act imposed automatic restitution on perpetrators and authorized over $1 billion in over 6 years to assist survivors and also to prevent further violence against women and children. The law has now since been renewed and strengthened 4 times, including in March of this year, when President Biden reauthorized the program and expanded funding to include increased services and support for survivors, with a deliberate focus on underserved communities, including LGBTQI+ survivors of domestic violence and assault. The law has also approved upon the healthcare system and its ability to respond to domestic violence and sexual assault, including through enhanced training for forensic examiners. In 2014, under then President Barack Obama, the U.S. passed the Crime Victims Rights Act, which is federal legislation that establishes new participatory rights for victims in federal criminal proceedings that directly affect their interests. In this respect, the law is starting to move in the direction of the Rome Statute. The law also establishes a right to victims for full and timely restitution as provided for by law, the right to be treated fairly, to have their dignity and privacy respected by criminal proceedings. And as a federal nation, the individual states within the United States can incubate new ideas. And my home state of California is establishing centers to focus on childhood trauma for children who have been the victims of crimes. Victims' funds help survivors and families receive compensation for physical, emotional, and financial harms, including psychosocial counseling and medical bills, particularly when there are injuries that make it impossible for people to work or to fully participate in society, lost wages and other forms of livelihood assistance, temporary housing for people fleeing violence or are displaced by the acts of an armed group, and even small costs such as replacing a door that has been kicked down by an abuser. These life-changing reparations can offer long-term support for survivors to heal in every sense of the world. And what our experience shows is that for acts of reparative justice to be effective, they must be responsive to the lived experience of victims and the lived contexts in which they operate. They cannot produce the very patterns of discrimination that facilitated the crimes and violence in the first place. As such, they must be conceptualized, designed, and implemented in a manner that is conscious about gender and racial dynamics, including the challenges faced by marginalized communities, such as, for example, male victims of sexual violence or LGBTQI+ individuals, who may be particularly vulnerable in situations of conflict. Reparations for women, for example, should not reproduce traditional gender roles, but empower women to achieve their own dreams and aspirations. This means at every step of the way, victims and survivors should be consulted and not merely the objects of reparative justice schemes. We recognize that these values find expression in a number of international instruments and institutions, such as the 1985 Declaration on Basic Principles of Justice for Victims of Crime, as was mentioned, the Global Fund for Survivors of Conflict-Related Sexual Violence that was established by the 2018 Nobel Peace Prize laureates Denis Mukwege and Nadia Murad, regional agreements such as the EU Victims' Rights Directives, but also national laws that are part of a transitional justice response. These reparative justice mechanisms show that victims and survivors are not just victims, but they're also rights holders. But it can also instill more respect, trust, and faith in institutions, and ultimately strengthen the rule of law, encourage social integration and reconciliation, bridge divisions within societies and communities that have been ripped apart by violence, and empower survivors to help them pursue their own life paths. This is where the essential work of the Trust Fund for Victims within the Rome Statute system is so essential. The Rome Statute system is not only aimed at holding perpetrators accountable and ending impunity, but also to offer justice broadly defined to victims. Thousands of victims, as we have heard, are currently registered in cases being adjudicated by the ICC, and there are millions in need of assistance in countries that have been ravaged by war, sometimes for decades, of conflict and intergenerational trauma. As embodied by the Trust Fund, the Rome Statute prioritizes the provision of tangible remedies to victims, witnesses, and their communities, our fellow human beings who are simply trying to live a life of dignity. A member of my team recently attended the field study to northern Uganda that was hosted by the Embassy of Ireland and the Trust Fund victims. It was really a transformative experience for her to witness firsthand the good work of the Trust Fund, but also to be able to inspire the rest of the United States government to teach them about the great work of the Trust Fund and the high levels of need within these situation countries. Even in northern Uganda, many years after the Lord's Resistance Army has left the area, the need is still acute. And she came back from that trip full of ideas about what more can be done. In addition to the welcome donations by members of the Assemblies of States parties, it's essential that the Trust Fund identify dependable and diversified means of raising funds to achieve and implement its important mandate. This challenge will be met not only by initiatives that engage the public sector, but also the private sector, including philanthropists, foundations, and ordinary people who recognize the potential of the ICC to contribute to a full scope of justice. In this regard, I'm really heartened to hear that very soon U.S. citizens will be able to give tax-deductible donations to the Trust Fund for Victims. I'm sure that they will be inspired by the work, and I look forward to brainstorming with the Trust Fund to think about how to reach the U.S. populace directly. So all of us, states parties and non-states parties alike, have a role to play in easing the suffering of survivors. Indeed, I want to specifically thank our co-sponsors, Sweden and Finland, for their consistent voluntary contributions to the Trust Fund. We really honor your reliable commitment here, and the United States hopes to be able to join you in your generosity soon. Thank you.
Thank you so much, Ambassador. This was a very inspiring speech, I think, for reparative justice, for reparations, also to hear from the US perspective what is happening there, and to really put the emphasis on empowering the victims, to allowing them to pursue their own life paths. And that is really at the center of what the Trust Fund is doing as well. Looking for transformative reparations and allowing the victims to really go on with their lives and bring something positive to their families, to their communities, not to carry with them anymore that harm in a negative way. It's a transformation in a way. Thank you so much. Also for, I think we look forward to working with you for the private donor market in particular. Thank you very much. We go now to the next member of the board of directors, who is also the reparations focal point, together with Ibrahim Yilla, signing off on decisions of eligibility for beneficiaries in the cases that are with us. It is Andres Parmas, who is also the Prosecutor General of Estonia, who has been formerly a judge at the Kosovo Specialist Chambers, also in Kosovo itself for many years. So an insider of international criminal law as well, who will now address us on the role of the trust fund in particular and the board of directors. Thank you very much for joining us.
Thank you, Francisca, for this introduction. I'm honored to have this opportunity to speak here to you. And allow me some reflections from the perspective of the Board of Directors of the Trust Fund. It is essential for the Board of Directors and the Trust Fund as a whole to be well interconnected to carry out its multifaceted mandate. First, of course, we need to be with the court, with its judges, the parties, in particular the legal representatives. The Trust Fund is not an obliged entity in the reparations proceedings, but a body of experts entrusted with the implementation of the reparations order, and in addition, the body that complements the payment of the award should the convicted person not to have the means to do so. It is, from that perspective, important to underline that without the Trust Fund, any reparations provision in the Rome Statute would hardly be more than an empty promise, given that so far all of the convicted persons have been found indigent. Any reparations orders by the ICC would have been without substance unless the Trust Fund complements. A conviction of the perpetrator that only carries a moral victory to the victims is, pardon me, somewhat meaningless and does not meet the victim's needs. As we just heard, you cannot eat the conviction judgment. The Trust Fund makes a difference here, as we may complement the payment of the reparations order even if the convicted person does not have the means to do so. The Trust Fund strongly supports an approach to reparations implementation that is victim-centered and community-based. And this is another dimension where the Trust Fund is intertwined. It's intertwined with the victimized communities, with local representative organizations and with organizations who immediately carry out our programs. We think that victims need to be empowered to take their lives in their own hands and be able to provide for themselves. The physical and psychological treatment is often a precondition for this. We involve the victims and communities as well as civil society as much as possible in the implementation of the reparations. They need to know what is possible in terms of funding and can then develop together with us what are measures of meaningful repair. The Rome Statute's reparative justice scheme is so revolutionary because it provides the opportunity to actually address the harm suffered by the victims in a meaningful way. With that, it provides for mitigating the negative transgenerational effects of the harm that is suffered by these victims. Empowered victims, they become survivors. With that, we actually contribute to peace and stability in the long run. Our new strategic plan and the theory of change developed in the past year focus on these elements. Our program, for example, in the Almaty Al-Faki case in Timbuktu is a prime example. But we need to be with the court and the registry not only for court-ordered reparations. We also need to be with them for the country programs that we can conduct in situation countries and that many states ask us to carry out. With these programs, we can deepen and extend the footprint of the ICC in ICC situation countries. In Côte d'Ivoire and in the situation CAR1, we are conducting programs even though the relevant accused persons were acquitted for lack of proof that they personally were responsible for the crimes that occurred. But these crimes, they occurred, and victims, they demand justice. Therefore, in Côte d'Ivoire, the Trust Fund is the body active in relation to justice and with a lot of impact. I must stress this. Such programs, they can only materialize when we have sustainable, earmarked contributions to do so. The Trust Fund can bring in its expertise already early in ICC situation countries to help establish reparation mechanisms. If these mechanisms exist, the Trust Fund can use them once a reparation order is issued, which often only happens years after the start of an investigation. I recall in this context that Rule 98.4 provides that the Chamber can, through the Trust Fund, request national and international organizations to implement reparations. Therefore, the Trust Fund has a mandate to work early on for this goal. In addition, early programs in situation countries, they can be open for victims that had contact with the court and address incidents or injuries that may be of great significance to the people, but that the prosecutor may not have chosen to pursue. This is more so relevant if no other national reparation mechanism has yet been established in this country. But these are not humanitarian programs that the Trust Fund is running, but these are programs that fall within the context of justice as reparations require, as a precondition that the beneficiaries have suffered of Rome Statute crimes. We encourage the court, in particular the registry and the prosecutor, to work with us to make the use of Trust Fund's expertise in situation countries more effective and to increase the visibility of the Trust Fund. Increasing visibility will inevitably lead to more funding for the Trust Fund and thereby extend the footprint of the ICC in the situation countries. A common strategy in relation to victims that are approached by the court and the Trust Fund, including an agreed outreach strategy, may be of great value to the victims. None of this is relevant, however, if the Trust Fund does not have the support of situation states and states parties. Without them, the Trust Fund's mandate cannot function. Broad financial and political support by states signifies support for its mandate and signifies to victims that the international community has an interest in their well-being. It signifies that we are not indifferent, that we are with the victims of the Rome Statute crimes. And this support does not end at the domestic level. The Trust Fund also needs support to become more visible at the international level with the United Nations and at the regional level, for example, with the European Union. The board and the Trust Fund have recently been very active in communicating with all these actors, but a lot still remains to be done. I sincerely hope we can walk this road together for the benefit of the victims. And the benefit of the victims brings me to my last point. a call for contributions. We have not yet been able to fully complement the Lubanga reparation order, but we need to find another 5 million euros, of which 2 million euros rather urgently in the next few months. It is encouraging that several states have started to increase their contributions, but we wish to call upon all states to contribute for the support of victims and to do so on a continuous, regular basis. This is not necessary for us, the Trust Fund. This is essential so that the idea of bringing justice to the victims of most horrendous crimes would materialize. Thank you.
Thank you so much, Andres, for this call, also for contributions. Our next speaker is Paulina Macida, the Principal Counsel for the Office of Public Counsel for Victims. And she's representing victims and either herself or her office is representing victims in all the cases that are actually pending with us, where we are implementing reparations. And so before you then continue speaking, we have a little video of one of your clients. All the clients are protected, and the team in Bunia, they managed to put this video together in a rather short time frame, even with English subtitles. So we can hear a beneficiary of the Lubanga case, a former child soldier, speaking about his experience receiving reparations. And then you can immediately start. Thank you, Paulina.
Je suis enfin soldat, j'avais entré dans l'armée en 2000 à l'IPC. Maintenant, en 2015, la madame Caroline m'avait appelé en me disant que non, c'est un projet où on va commencer par rapport à bénéficiaires, les gens qui n'avaient pas bénéficié. Et j'avais dit c'est bon. Alors après 2021, on m'a appelé à Port et je suis entré dans le projet par rapport à avant, mais maintenant le fonds m'a beaucoup aidé parce qu'ils m'ont pris à charge santé et j'avais trouvé mental parce que je prenais des charges et maintenant je me sens très à l'aise. Avant, on me prenait comme aide de camp, un phaser, mais maintenant je suis responsable, j'ai nourri mes enfants et je les fais scolariser grâce à vous. Alors je dis merci beaucoup à vous. Merci, merci à tout cas. Il m'a remis aussi une somme d'argent pour agir. Donc j'ai acheté une moto, ça me permet de bien nourrir mes familles. Et maintenant j'ai fait aussi des formations grâce à vous toujours. Alors maintenant je suis désigné dans un hôtel. Alors je dis merci beaucoup à vous. Merci à tout cas, merci pour me soutenir. En tout cas, je vous dis merci les fous. Je demande aussi à vous de beaucoup aider les autres afin qui n'ont pas eu les moyens de faire soutenir parce que nous étions nombreux en tout cas, mais ce sont les pays qui ont eu les moyens. Mais maintenant, on me parle à valeur par rapport à avant. Avant, j'étais délicat, mais maintenant, je suis très très bien. Je suis responsable aussi. Merci et merci beaucoup à vous.
Thank you very much for this event, which I think is extremely important. Speaking of reparative justice is essential in the framework of the Rome Statute, and I think that initiative like this one should be much more in terms of events, in terms of initiatives, in terms of people speaking about the importance of reparative justice. Now, the video that we just saw, it's the perfect introduction to the few reflections that I wanted to share with you today. We have heard quite a number of important issues from the different panelists. Justice responds to part of the queries of victims in terms of knowing what happened, in terms of knowing the truth, in terms of impunity. But without the recognition of the victimization of each of them, it will not be possible for each of them to turn the page. In this sense, reparation is an essential element in granting victims the possibility of paving their new life after the terrible events they suffer from. And my first reflection today is rightly on the importance of listening to the victims. It's essential to hear the voice of victims, what they want for their life, what can be done for them after the events they suffer from. Very often I ask myself what we repair. The term repair in se is already, to some extent, in my view, reducing what is the impact that realizing reparative justice means. Because reparation is a term that implies that something can be done for victims who suffer so much and that they can continue their life. Now, this is possible for the vast majority of them, but not for all. And also the way in which we think about reparative justice, it's important because it has to cover the different needs and wishes of the persons. It has to cover what is important for a victim and what can make the victims turn the page of what happened to him or her, but in a context which is different for each of the victims because of the age, because of the gender, because of the society, because of the community. And the role of a lawyer in this process is rightly to give victims a voice, to understand what matters to them, and to be able to convey that messages to the judges first in order to have reparations order which fit in the country, which fit in the society, which fit with the needs of the victims. But then the role is also to some extent to accompany victims. It's a way, it's a long way. You have seen in the video someone saying, I was recontacted in 2015 by a lawyer, asking what about reparation? But then only in 2021 this happened. So there is also this component of a long period of time passing, which makes a huge difference for victims, because what you may collect as important needs in 2015 may not be any more important needs in 2021 because the person evolved. Because maybe in 2015 the person was still single, in 2021 the person will have a family with 4 kids and maybe no job. So there is a need of thinking about reparative justice not in a structured way, but also in a flexible way. There must be a way of conceiving reparation in a holistic manner, in a structured way, because otherwise it will not be possible to plan forward, but also giving flexibility in the plan in order to cover for the different needs and the evolving needs of each of the victims. And you have probably noticed that I'm using each, because it's not a general process. It's a process which has to touch each victim individually. And this is the complexity of a process. And this is where the richness of a process is, but also the difficulty, because with the resources that the Trust Fund has, you need to cover a lot of needs, a lot of wishes, in a way which really render the person much more empowered and much more ready to continue his or her life. So one reflection for me is the importance of victims' voice in the process. Second, the complexity of the reparations proceedings, but also the flexibility that we need to take into account. And third, the third reflection that I would like to make is the importance of cooperation and coordination amongst the different actors implicated in this process. Each has a role, different, but all together we aim at one single result, the benefit of victims who suffer so much. And I think that we can only arrive at very concrete result if we all work together towards a common goal. Thank you.
Thank you so much, Paulina, for underlying the need, indeed, for a holistic, structural, flexible system, individualized, and in particular, the need for coordination and cooperation, which we live together with our team in the field, who can unfortunately not participate because this is an in-person event only, but they are with us in their thoughts. They hope, they were really thinking of this event as something really essential to their work, of course. We are having three more agenda points. We have a small presentation that will simply show you in pictures with some text, what does it mean, reparative justice? Who are all these actors dealing with it? And I will perhaps make some remarks while this is running, and followed by then the perspective of the evaluators after the implementation or at the end of the implementation. And that is, we are looking through, we are looking at a study that is not yet complete, and that is basically the final point. And then we will have very little time only for questions, and perhaps I suggest that some questions already perhaps be collected. Maureen, if we could go in the meantime perhaps and ask whether we can collect them already so that we are able to answer them still, so that people can address that. Thank you. We go to the presentation.
Thank you, Francisca. Before we hear the experience of victims coming from this evaluation.
Actually, I will introduce you.
Yes. My name is Ejidi Murekatete. I'm the Monitoring and Evaluation Officer at the Trust Fund. I'm working with independent researchers from Edinburgh University, Professor Jean Benoit and Simeone Karoma. So we are happy to share with you one of the findings that came from the evaluation of the Katanga reparations. Before we hear from what the victims are saying, I would like to briefly say that Trust Fund has a monitoring and evaluation function that supports our real learning, our real-time learning and understanding from the implementation process of these reparations, to hear what victims are saying, for us to make timely adjustments, also document our success from these programs. So these evaluations allow the Trust Fund as well as our stakeholders to know and understand what these reparations made in the lives of victims of the Rome Statute, and what can we learn, what worked well and what didn't, and what adjustments needed for the future programming. The findings also help us at the fund, as well as our stakeholders, to make informed decisions, resource allocations, and also to meet mainly the needs of victims in the context you're working with. Currently, we have a number of evaluations going on. We have Katanga evaluations, which is almost complete. We started evaluation in the Lubanga reparation program. Next year, we are moving to Al-Mahadi as well as impact evaluation for trust fund assistance mandate in Uganda. All this evidence we are collecting now is to inform our stakeholders as well as ourselves on how we are meeting or addressing the harm of the victims of the Rome Statute. So I'm giving the floor to Simeon and Jean-Benoit to share the results so far of what victims are saying after receiving a reparation in the Katanga case. Thank you.
So thank you so much, Ejidi. Ejidi Murukatete is our monitoring and evaluation officer with the Trust Fund since 2016 and is in charge indeed of having procured the assistance of our two evaluators from Edinburgh University. At the same time, you have now seen a presentation. We will show that later again, but I think we are switching now to the presentation of the two evaluators. Perhaps to introduce them, we have Simeon Koroma, researcher. He's a postdoctoral fellow at the Center of African Studies of University of Edinburgh. And Jean-Benoit Fallis, a senior lecturer, associate professor in the School of Social and Political Science at the University of Edinburgh. Please, you have the floor.
Sorry, could we go to the second slide, please? It's not this one. Next slide. One more. Yeah, thank you. Perfect.
Thank you, Francisca. So just to give a brief overview and context, in March 2017, as we all know, the trial chamber issued an order awarding reparation to victims in the case of Katanga. This reparation order came 3 years earlier, in 3 years, after the conviction. The order awarded both individual and collective reparations. In terms of individual, there was a symbolic award of $250, and the collective awards were for the following areas: education assistance, housing assistance, income-generating activities, and psychosocial rehabilitation, as Ejidi mentioned. Apart from the last award, all the three collective awards are almost done. I should note that there are two approaches in the Katanga reparation process that are, of note. And the first one is just the flexibility of the implementation of the collective orders. And what this basically did was it allowed victims to choose the specific orders they wanted, and also gave them the possibility of changing that choice. The second was the direct implementation of the reparation order by the trust fund. Now, it is in this context that the University of Edinburgh in the UK has been contracted to conduct the independent evaluation. Now, based on the specific research questions we are considering in this case, including one, how have reparations been implemented? And two, how have reparations affected the well-being and the sense of justice of victims? We have employed a mixed methods approach, partly to mitigate the challenges of attribution. Jean-Benoit will say more about this in subsequent slides. including the details of the control group. So in addition to the surveys, which, by the way, have been conducted by our fantastic team of field researchers in DRC from the CMRDC organization, with input from Inanga, and this is a group of international researchers that are working with us in these reparations evaluations. We have also conducted 23 focus group discussions, 13 of which are with victims and 10 with community members. We have accounted for gender in these focus group discussions. We've also completed 17 semi-structured interviews with victim leaders and are in the process of conducting more than 20 key informative interviews, mostly here in The Hague. Our hope is that by the end of this week, we would have completed most of them. We should note that there is no data at the moment for about 50 of the victims. Of that number, about 30 of them are outside, abroad, some outside DRC, and about 20 are residing outside Ituri. So here we start to discuss some of the preliminary results emerging from the data. Now, for the purposes of this presentation today, we have divided these into two. First, the experience of the process from the point of view of 253 beneficiaries living in Ituri. And second, some of the possible effects of reparations. So starting with victims' experience with the process, this slide you're seeing now mostly focuses on communication. So based on what you're seeing, the preliminary results we have, about 2/3 of the victims we have surveyed and the focus group discussions that we've started and the data we've started analyzed, about 2/3 of them basically express feeling heard in the system. And there is even a higher percentage of those who feel that they are being updated or they have been updated about the reparations process. Now, these are very high percentages, as you would notice. But we would also want to put this into perspective, as we do not want to paint this very rosy picture that everything was smooth and everyone was happy. It should be noted, for example, that victims displayed or at least expressed unhappiness with the delays and the length of time it took to get the process going. Having said that, the data so far shows that overall, victims felt that there was decent communication within the process, and this was good, generally. Over to you, Jean-Benoit.
Thank you very much, Simeon. So let me now turn to some of the outcomes of the reparation process. So on the slide, you can see answers to 3 fairly broad questions: whether victims felt that reparation has been achieved, that justice has been rendered, and that the reparations were useful to them. And the results are pretty similar across indicators. Of course, we need to remain careful. This is only based on the quantitative data on the survey. We still need to analyze data coming from the qualitative interviews, from the focus groups. But it seems clear that for most people, the experience is a generally positive one. At the same time, as you can see on the slide, the vast majority is expressing a feeling of a rather positive experience, but not a fully or absolutely satisfactory one. We're still working on the data, but the story seems to be only in part a story of technical issues with the process. There were technical issues. A well-known one is, for instance, that at the beginning of the process, the victims who had picked the housing option were shown some drawings, some pictures of houses. They got really excited about them. And then a few years down the line, the houses had become too expensive, and this is not what they were provided. This obviously generates dissatisfaction with the process. But really what is a lot more central and comes up time and again in the interviews, in the focus groups, even the survey, is that there is still no peace in Ituri. And that quote on the slide really sums it up. It came from a focus group, and that's pretty much all there is to say. There is still no peace, and because there is no peace, people feel that there is no way that they can fully achieve reparation or even justice. The beneficiaries still live in an extremely violent environment, and they continue to suffer from it. Just one figure, in the decade after the Bogoro massacre, so about the decade between 2010 and 2020, no less than 64% of the beneficiaries say they experienced a prejudice that is potentially as severe as the one they suffered during the massacre. One fact, not a trivial fact at all, actually. Beneficiaries spoke of armed men stationed just a few kilometers away from the village of Bogoro. These armed men are not causing any trouble, but everyone knows who they are, and they are closely related to Germain Katanga. More generally, I think the feeling is that on both the reparation and the justice fronts, the work is not finished, and not all perpetrators and organizers were prosecuted. This is what beneficiaries report. This is not a normative judgment on what happened. This is really what came out of the interviews and focus groups. And against this background, I think it's not very surprising that 68% of the victims say that they still expect more reparations to come. And as you can see from the slide, we're not talking here primarily about the psychosocial component that just started. So let me now move to the second part of our presentation and go back to our core question: what difference do reparations make for victims? It's a tricky question. A lot happened in Ituri and in the life of the victims since the Bogoro massacre. It's almost 20 years ago now. And a lot of what happened has very little or nothing to do with the trial or with the reparations. So how can we then attribute any effects, anything of what we see, to the reparation process? Our approach has been to try and find a group of people who live in the same context as the beneficiaries and who could be therefore compared to the victims. In other words, people who suffered a prejudice similar to the beneficiaries but have not benefited from the reparations. Very sadly, people with such profile are not too hard to find in a context like Ituri, where so many war crimes go unpunished. So as you can see from the slide, we surveyed 887 people, identified some people who were beneficiaries or victims of Katanga. So among the victims, we have a group of people who are indeed beneficiaries and a group of people who identify as victims but did not receive any reparations. There might be many explanations for that, one of them being that some people were refugees or were internally displaced at the time when the list of beneficiaries were drawn up. And then we have another group of people who are people who live really in the neighborhood of the beneficiaries, and you can see we have 431 people who suffered prejudice that they say is similar to what we have in the Katanga case. What do we find? As I said, we're really at the beginning of this, and I want to be extremely careful here. But if we compare the three groups, and we have some basic controls, so we make sure that we control for gender, for age, for education. We're not yet using the most advanced statistical methods that we will use eventually. What we do seem to see is that beneficiaries are slightly better off when it comes to economic stress, when it comes to empowerment, when it comes to social connections. Again, we need to do more work on this, but what seems to be happening is that some form of resilience is being built. In one domain, in particular trust, the difference between groups is quite stark, and this is what you can see on the slides. We asked people how much they trust key institutions and actors, and as you can see, beneficiaries have much higher levels of trust. This is the case, of course, when you look at trust in the ICC and in the fund, you would expect that, but also if you look at trust in the UN peacekeeping mission, the MONUSCO, local chiefs, and DRC authorities. So, as I said, this is very much work in progress. We're hoping to have many more results over the coming weeks. There are many themes that we still would like to explore, for instance, on gender dynamics, and possible differentiated effects depending on the socio-demographic characteristics of the victims. At this stage, and just to sum it up, we find generally positive experience of the reparation process, with a big caveat, though, the question of peace. And we find some suggestions that besides the generally positive experience with the process, reparations are actually helping victims in their lives. Thank you.
Thank you so much to both of you for this study and for really giving us, at the end of this session, such a positive feedback on the work that has been done, that there is indeed a reparative effect and that this is measurable. You were able to measure it. We are looking forward to receiving the final study with all the different results, but I think that is a very important conclusion. And I now need to give you just some very extremely short concluding remarks, because we cannot have questions anymore because the main session will start in 15 minutes. And perhaps just to address three big challenges. One is expectations of victims, where we all need to work together. The registry from the start, the prosecution from the start, to manage these expectations of victims very well. That is one of the issues we have also heard from Paulina and from the researchers. If we want to be successful, we need to manage these expectations. The other one is peace. We don't have influence so much on it. And even though there is no peace in really key regions where we are active, we do have a positive impact. There is more resilience, but nevertheless, I think it is very essential to keep working on that overall message that there shouldn't be any impunity in these regions. The third area is, we heard that as well from also from Beth van Schraak, we need to include the victims in the processes. It's so essential. This takes time. This also takes money, because taking time means we need to invest in programs that include victims. But we see this empowerment so much in the Al-Mahdi case, for example, in Timbuktu, that victims get from being included, from being the agent of the reparations. And that is what we want to actually achieve. I thank you so much for being in this panel, for giving your contributions, your idea, making your calls for contributions of others. And I do hope we have more of these panels, more of these conferences, more of these opportunities to speak up for reparative justice in the coming period, and to also value the essential role of the trust funds programs and the people of the trust fund in the field in that respect. Thank you very much, and wishing you a very good afternoon session of the ASP. Yeah.